All right, I think we're ready to begin. Wanted to thank you all for joining us for our California employment law update. This is our annual webinar on all things California. And I am Andrew Sommer, the managing partner of the California practice at Carey. I'm pleased to be joined by my colleague, Megan Shaked. And we are going to cover a variety of different California employment laws, most of which took effect January 1st, some of it which are in the workplace safety realm, given COVID and the impact it's had on the workplace pervasively, as well as a variety of employment laws that have taken effect. And so before we begin, wanted to just briefly introduce myself. So I am a partner at Carey. I've been practicing for over 20 years, defending employers in employment-related litigation, whether that be an individual lawsuit or a collective action, such as a class action or PAGA suit. And my concentration has been on wrongful termination cases, wage and hour litigation, whistleblowing, and a variety of other employment-related claims. Also have a dual specialty in Cal OSHA matters, handling enforcement proceedings and appeals before Cal OSHA, as well as advising employers on employment-related litigation. And so at the get-go, our firm, it has a specialty in employment and labor, and as well as workplace safety. And so that dual practice has really, been critical in the age of COVID, in evaluating, following the various COVID-related laws. And so I did want to emphasize that next month we will be having an OSHA webinar that will dive deeper on the workplace safety issues, particularly around the COVID-19 emergency temporary rule. But we're going to cover that standard a little bit more generally, and then in addition to all of the different employment-related changes this year. But then I'm going to turn it over to Megan to introduce herself.
Thanks, Andrew. Hi, everyone. I'm Megan Shaked. I'm an associate in our San Francisco office out in California. I also practice in both Carey's employment practice and workplace safety practice with all of our Cal OSHA work. So on the employment side, I also defend employers in litigation in federal and state court and advise on compliance with employment laws, covering same sorts of cases as Andrew, a lot of wrongful termination and a lot of wage and hour cases in recent days. And then on the Cal OSHA side, handling appeals from citations and advising employers on compliance with Cal OSHA regulations.
All right, so to start with our agenda, we are going to first cover the COVID-19 emergency temporary standard under Cal OSHA, as well as the COVID-19 supplemental paid sick leave. And if you're surprised by the supplemental paid sick leave, that's understandable because it just took effect. It's essentially a renewal of past sick leave laws with some differences that Megan will cover shortly. We'll also cover some updates to the California Family Rights Act for unpaid leave for smaller employers. We'll also address clarifications to prohibitions relating to settlement agreements and non-disparagement agreements. And so that we'll cover those changes and how we recommend you updating your template agreements. Also, there was a very significant law that took effect later in the year that relates to warehouse quotas for workplace environments. And that was essentially a law that was looking for a problem that we believe did not exist, but is creating new obligations on employers in warehouse settings. And then there was a similar pharmacy quota law. And then lastly, we'll cover a variety of different wage and hour developments that have taken effect this year. So let's dive into the COVID-19 emergency temporary standard. In the next slide, wanted to review with you just the timeline. I'm going to focus on the most recent changes that took effect. This has been this living rule where it has been constantly evolving to the great consternation of employers, and it's been very difficult to keep track of. And so if you've had difficulty, you're not alone, and we have been reading the tea leaves throughout the rulemaking process and consistently revamping our thinking as we have new guidance and new rules. But just wanted to give you a very general overview of the emergency temporary rule. And in the past, there have been workplace safety standards that have been focused on certain industries. But really the ETS is very broadly based. Oh, if we could go back one slide. Oh, perfect. So wanted to go over the timeline. So briefly, there was a petition from a labor group, WorkSafe, to adopt a COVID-19 emergency rule. And that petition was granted back in September of 2020. And then there was some work on a emergency temporary standard that was eventually effective November 30th, 2020. And that was a multi-page document, very dense, rushed through the rulemaking process, and in many ways completely unintelligible. And so it took months to try to figure out what this document was attempting to convey as the requirements. And then once we were really getting our hands around what the obligations were, then they convened an advisory committee to consider revisions. And our firm did serve on the advisory committee for the OSHA ETS and had advocated on behalf of the Employer Coalition in that process. And there was a readopted ETS, and there was really this tremendous drama about that process. You may have heard about it in the news, but there was an initial standard that had been approved, was about to be approved, then there was an about face, and it was eventually approved, effective June 17, 2021, with some significant changes particularly around removing the requirement for physical distancing, modifying the masking requirements, among others. And then then there was a second readopted ETS. And so essentially the readopted is a revision to the ETS. So there was the first change that took effect in June 2021, and the second revision took effect just last month on January 14th. And so I'm going to focus on the changes that just most recently took effect. And then there will be an expiration of the latest version of the ETS. And given the emergency rulemaking process with the OSHA Standards Board, there is a limited duration of each rule. And so there was an extension of the deadline by executive order. But presently, by executive order, the rulemaking process, emergency rulemaking process, can go on until the end of December 2022. So we expect that there will be a readoption of the emergency rule and then potentially a consideration of a permanent COVID rule. So now I think we can go to the next slide and addressing the application of the ETS. And this is really important to note that the ETS applies to almost any workplace. There's very limited exception. And so typically in many workplace standards, there is a more narrowed scope of the applicable workplace. Here it applies to any place of employment. That's pretty darn broad. There are some exceptions for employees who work from home or other location of their choice. So if they're teleworking, it would not apply to them. Or otherwise if they don't have contact with others. And then the other really significant exception would be if it's an employer for example, in the healthcare industry that's subject to the aerosol transmittable diseases standard. So that is a significant standard that's no easy feat to understand. So if you're not in the healthcare industry, you don't need to worry about that. If you are, you'd likely understand the rule. And then the really important caveat for the ETS is that it does not limit more protective or stringent state or local public health mandates or guidance. So what's really important to keep in mind is that although you are following the ETS for compliance purposes, that's enforced by OSHA, you also need to be aware of the public health orders. And most recently, a significant divergence has been with the state public health order regarding masking that was in effect until, I believe, yesterday. It wasn't renewed, and that was more protective than what was under the existing ETS on masking requirements. So then next on the following slide, I wanted to cover just very generally the requirements for a COVID-19 prevention program. There are very clearly delineated categories of information that must be in your COVID prevention program document. It's similar to what is required in a way with the Injury and Illness Prevention Program. So all of you should have a COVID-19 prevention program in writing. There has been some talk about doing away with the requirement of a concrete written program document, but currently it's still a requirement. So there's various different components like the Injury and Illness Prevention Program you're required to establish with a written document, this program, and then you're required to implement and maintain it. And so some of the elements, and this will be covered in greater detail at our OSHA webinar, but there is a requirement to communicate with employees about the program, investigate incidents of COVID cases and close contacts, inspecting sources of infection and correcting known COVID-19 related hazards, and then conducting training of employees on COVID-19 related concerns regarding very specific enumerated topics. And then next, they're addressing specifically the requirement to respond to COVID-19 cases. Many of you may be aware of a requirement that within 1 business day you give notice of the COVID-19 case, which is essentially a positive case in the workplace. And so you're required to give that notice to certain categories of information of individuals within the work site, but without revealing personal identifying information for the COVID-19 case. And so what is key is that you give this notice fairly broadly to employees who are on the premises at the same work site as the COVID-19 case during the high-risk exposure period. So essentially when the COVID case was infectious, when the individual was infectious, the individuals that were in that work site need to be given notice. And so it's not everyone on site at a multi-building campus. It could be limited to an individual building or even maybe just a floor where the individual entered. But it's a term of art, really determining what the work site is, and I'll leave that for another day. But just in a nutshell, you need to give notice to employees who are on the premises during this period. Also, you need to give notice to independent contractors that you've retained, as well as the employers of other workers, other trades that are on the premises at the same work site during this high-risk exposure period. And then if there is a union, you'll need to give notice to the union, and that's a union of the positive case as well as any employees who had a close contact. And so part of your response in this situation where you have a positive case is also doing close contact evaluation, determining who have been close contacts with this positive case and taking appropriate action, including excluding the close contacts as individuals having close contact as appropriate. Okay, and so let's move to the next slide. And so just a note for clarification here is under the ETS, there has been this notice requirement to individuals at the work site. And there is a parallel law, which is AB 685, Labor Code Section 6409.6, that provides the same notice requirement to employees, to unions, to independent contractors. There has been some clarification, maybe 685 on those requirements. and that those requirements have been, those amendments to the requirements have been incorporated into the ETS as well. And I thought it was important to make that point. In addition, AB 685 just clarifies the reporting requirements for an outbreak as defined by public health guidance. And that reporting, it must be made to the local public health agency. And now the requirement is that that reporting be within 48 hours or 1 business day of the outbreak, whichever is later. And so it's important to note that where you have an outbreak as defined, that is reported to the public health agency, the local public health agency, and not to OSHA. But where you have a COVID case that results in a fatality or inpatient hospitalization, where it's work-related, arguably you would have a report in that instance to OSHA. And the AB 654 does have certain exemptions from the outbreak reporting for industries, and these are industries that are like highly regulated anyway, such as child care facilities, licensed care facilities, typically in the healthcare setting. And then the covered work sites do not include locations where the employee identified as a source of COVID-19 exposure worked alone or worked remotely or did not enter a location. So that's a point of clarification. And then for the next slide, COVID testing. There was a change in the second readopted ETS taking effect last month regarding testing. And so there was presently testing, previously the testing was required for employees that were unvaccinated. But presently you must, under the revision, there is a requirement to offer COVID-19 testing at no cost during paid time to all employees having a close contact in the workplace. And that's regardless of vaccination status. So it's quite broader. And then there is a requirement under the current ETS for COVID-19 testing to be observed by the employer or an authorized telehealth proctor where it's not a laboratory test. And so it's a requirement that the testing cannot be both self-administered and self-read by the employee. And interestingly, this was a requirement that was taken by the Fed OSHA ETS or by concerning vaccination or testing that had been stayed by the US Supreme Court. So that rule has effectively gone away, but it's somehow been incorporated into the ETS to the great consternation of employers. And so we've been advising clients consistently on this issue, and it's created some concerns, particularly around the Omicron outbreak, that there has not been the bandwidth for many companies to be observing every single test. And so there are a number of ways that this can be addressed that we might be able to answer some questions. And as a parenthetical, we will save some time at the end for questions. And so some examples of approved tests would be a test process by a laboratory. So that could be something, it could be testing that's done where you go on site and they collect the specimen and then it's laboratory tested, or it can be a home test that's sent to the laboratory for testing. There's also proctored over-the-counter tests and otherwise tests where specimen collection processing is done or observed by an employer. So let's turn to the next slide. And physical distancing, it's really important to note that there no longer is a physical distancing requirement under the ETS. But a really important exception is where there is an outbreak. There's two types of outbreaks. There's what I refer to as a simple outbreak, and then there's the major outbreak. And for the simple outbreak, the employers must consider whether it is necessary to implement physical distancing during an outbreak. So they must evaluate, but there is not a required course of action. But where you have a major outbreak, you must implement physical distancing. All right, so let's continue on in face coverings. This was another significant change, starting with the June 2021 first adopted ETS, and then some further changes under the second readopted ETS that took effect last month. So fully vaccinated workers are not required to wear face coverings, but there is an exception that if there's a person screening employees for COVID-19 symptoms, they must wear a face covering regardless of vaccination status. And under the existing rule, employees who are not fully vaccinated must wear masks indoors or when in vehicles, with limited exception. And an important consideration is the California Department of Public Health guidance that as of yesterday or through yesterday required face coverings indoors for all workers, not just those that were unvaccinated. So then moving to the next slide. And I did want to mention that employers can institute more protective measures. So there are many employers that even when there's no masking requirement will require face coverings in the workplace, and that's certainly the employer's prerogative. Now, respirators. And so respirator is different from a face covering. That would be akin to an N95 respirator. And of course, there's been this sensitivity around the use of N95 respirators given their shortage during the pandemic. And the current iteration of the ETS states that upon request, employers must provide respirators for voluntary use to unvaccinated employees working indoors or in vehicles with others, and that must be done as soon as possible. And so there were some prior frequently asked questions, FAQs, that address this, and the position that has been taken by the Division of Occupational Safety and Health is that employers must either have these respirators in stock or must poll workers to determine, who wants them. And so given the cost of N95 respirators, the issues of oversupply, one helpful idea has been to have some sort of notice that goes out to employees, like a poll that tells them that they have a right to, that they may request respirators if they're unvaccinated, and to let you know if they would desire one. So then all of a sudden, if you have a flurry of requests and you don't have them in stock, you can show that you've complied in good faith. And it's important also to note that you must have the correct size and type of an N95 respirator. So you want to have, 2 or 3 options for your workers. And then we're going to turn to exclusion pay. This issue has really garnered the attention of organized labor, and they've really pushed this. This has resulted in the supplemental paid sick leave law that Megan will cover shortly. But there is an exclusion pay provision in the ETS. We are hopeful that that will be removed. The last draft that was being considered for a permanent rule that was drafted by the division had excluded exclusion pay given the impending state legislation on this. And the benefit of removing exclusion pay from the ETS is it has no cap. I mean, you could have employees that are frequently using exclusion pay because they test positive or they're merely a close contact and may not have it develop symptoms. And so the real crux of this is that the ETS has language that recognizes avenues for enforcement outside of OSHA. And so Megan and I are both wage and hour litigators, and in addition to OSHA practitioners. And I would be more concerned about a wage and hour lawsuit than OSHA enforcement, since in a wage and hour lawsuit, you would have very significant wage recovery and attorney's fees, and it'd be fairly costly to defend. And so I want to discuss this just briefly. that if you have an employee that tests positive for COVID or is a close contact, there is potentially the eligibility for a wage continuation and continuation of other benefits during the time that they need to be excluded from work. Exclusion pay, however, is not required for close contacts or individuals having close contacts where the employer can show that the employee's exposure was not work-related. So if the exposure that the employee had was outside of work and that could be shown it wasn't a work-related exposure, then there's no requirement to provide exclusion pay. And it's really important to note that the employer should be documenting through a work-relatedness analysis the different potential exposures the employee had where they test positive and where there's a close contact potentially. And through that, that's where you can reach your own conclusion about whether there's a work-relatedness that would require wage continuation of benefits, but the onus is on the employer to establish that. There is sort of an ambiguity right now under the current law whether a positive case is entitled to wage continuation and benefits continuation where the exposure was outside of work. But in a way that is moot under the current supplemental paid sick leave law that we will cover shortly. And then lastly, exclusion pay is not required where the employee receives disability payments or is covered by workers' comp. So if there's an active disability or workers' comp claim, that would supersede the exclusion pay requirement. So then turning to the next slide. And then there is, I don't want to take up too much time with the ETS because we have plenty of other material to cover, but just a really important consideration here, and it is that the governor signed an executive order back in 2020 that stated that the ETS exclusion return to work periods are suspended to the extent they exceed any applicable quarantine or isolation period recommended by the California Department of Public Health. So if the department comes up with a quarantine or isolation period that allows employees to return to work earlier than provided under the ETS, then that would trump the ETS in that regard. And so the OSHA has taken the position through FAQs that the California Department of Public Health guidance that issued on January 6th that largely tracks the CDC guidance on exclusion and quarantine periods, that replaces the ETS. So let's just move to the next slide and walk through some of these examples. And this is not an example of clarity of agency guidance. And so you may have many questions about this. You can certainly reach out to us independently if your questions aren't answered today. But in a nutshell, there were some changes to principally, well, first off, to the isolation periods. Isolation refers to someone that is a positive case that needs to be isolated from the workplace because they're infectious. Now, under this guidance, an employee who tests positive for COVID-19, regardless of vaccination status, must be excluded from the workplace for at least 5 days. And they can return to work after the 5th day if they do not have symptoms and they have a diagnostic specimen collected on day 5 or later that tests negative. So they have to have a negative test. So if they continue to test positive, then they need to be excluded for a full 10 days. If they meet the requirement for testing and receive the negative test earlier, they can return earlier than 10 days. And the key requirement is that the employee wear a face covering around others at work for a total of 10 days after the positive test. So if they return to work before the 11th day, they need to be wearing that face covering regardless of whatever mandate you may have under public health guidance. And so let's turn to the next category. The following categories relate to close contacts. So, okay, Megan, if you could move to the next one, which is perfect. So that is for quarantine periods for close contact. So there's different categories. The first one is for, and it all depends on your vaccination status. And so if the employee is unvaccinated, then that individual must be excluded from the workplace for at least 5 days after the last close contact. And then the employee can return after day 5 if the employee is negative, has a negative specimen collected, and no COVID-19 symptoms. If the employee declines testing, doesn't get tested, then the employee cannot return to work until after the 10-day period. And like the requirement for isolation, the employee must wear a face covering for the full 10-day period if the employee returns earlier. And there's some other requirements. I think we can skip to the next category, the next slide, which is for employees who are vaccinated and eligible for boosters but are not boosters. Then that employee does not need to be excluded from work if asymptomatic, but must have a negative test 3 to 5 days after the last close contact. But if the employee is not tested, then the employee must remain off work for the full 10-day period. And there is no guidance from OSHA recognizing any relief for the employer if the employee on his or her own declines testing. So in that situation, the safer bet is just to exclude the employee for the full 10-day period. And then there's also the requirement that the employee wear face covering for the full 10-day period, like in the other instances. And then let's move to the next slide, which is employees who received the booster. So they've received the first doses of the vaccine. They've also received the booster, or they are not yet eligible for the booster. And in that situation, the employees do not need to be excluded from work if they're asymptomatic, but they must take the test on day 5 after exposure. And then there's the same requirement for face coverings before day 10. And and like in the other examples, if the employee develops symptoms, they must be excluded pending test results. And then, as with the other quarantine examples or scenarios, if the exposed employee tests positive, you follow the isolation requirements from the first slide. So let's move to, one other point I want to make. We can stay on this slide, but one point I want to make about the exclusion requirements is there is a exception in the ETS for employees who are fully vaccinated, that they can return to work promptly after having close contact, but they must wear a face covering and maintain physical distancing at all times. Since that is a lesser period potentially than what's provided for under the agency guidance, the California Department of Public Health guidance, then that would apply in that instance. But the really core requirement there is that you have to maintain physical distancing, which might not be feasible in your workplace. And there's also a similar exception for employees that in the last 90 days tested positive for COVID-19, that they could return promptly to the workplace, provided that they mask and that they maintain physical distancing for a certain period of time. That exception has not been expressly recognized in the OSHA FAQs, but we believe that exception will be alive despite the public health guidance. And then for testing, I think a key exception, or there are different requirements when there's a simple outbreak and a major outbreak. An employer must make COVID-19 testing available at no cost during an outbreak. And the big change was that in the most recent update, the exception for vaccinated employees was removed. So asymptomatic, fully vaccinated employees are no longer exempt from testing. And then I think we can skip the rest of the slide. Okay, and so the last point I want to make about the Cal-OSHA rulemaking over COVID-19 is just the myriad of different standards, legislation, and guidance that applies. And so it's important to follow not just the ETS as a rule, but also there's frequently asked questions by DOSH on the ETS and other subjects that are available online. That it has no legal effect, but it's helpful to understand the direction in which DOSH would go in enforcement. There's also, of course, the guidance from the Department of Public Health and on the state level as well as a local level. And then there's potentially executive orders that we should be looking out for. So then I believe that ends this subject, and I'll turn it over to Megan to discuss the paid sick leave.
Great, thanks, Andrew. Okay, so while the concepts of exclusion pay and return to work are fresh in your mind, we can turn to this brand new 2020 COVID-19 supplemental paid sick leave. So yes, this does sound familiar. There were previous versions of supplemental paid sick leave for COVID-19 purposes. The most recent version expired September 2021. So we had this little gap here. And now this is effective on February 19th, but it's retroactive to January 1st, 2022. So it's essentially in play now, and it applies for employers with more than 25 employees. And there are essentially two buckets of time that employees might be eligible for this supplemental paid sick leave. The first bucket is essentially up to 40 hours for reasons related to COVID-19. And we'll go over some of those reasons momentarily. And then the second bucket is essentially if an employee or a family member actually tests positive for COVID-19. And this is above and beyond just general California paid sick leave that's required. And it's above and beyond any previous COVID-19 supplemental paid sick leave that may have been provided or required. There is, however, some allowance if, say, a local ordinance were to pass a new version of supplemental paid sick leave, then you might be able to meet both the qualifications for the local ordinance and the qualifications for this 2022 supplemental paid sick leave. And again, it's retroactive to January 1st, 2022, and then it continues through September 30th, 2022. So that first bucket of leave, the qualifying reasons all relate to COVID-19, but not necessarily having an actual positive case. So the most typical qualifying reasons you might see are an employee experiencing COVID-19 symptoms, though they have to be seeking a medical diagnosis. Or if you have an employee's child whose school gets shut down, or a daycare center gets shut down because of a COVID-19 outbreak, for example, that would be a qualifying reason. There's also some qualifying reasons related to vaccinations, including boosters, for not only an employee or a family member going to attend that vaccination appointment, but also having symptoms related to the vaccination. And then, as we saw with other versions of this law, there's some qualifying reasons related to specific isolation or quarantine orders, or a notice from a healthcare provider to isolate or quarantine. And then the second bucket of time is the qualifying reason is where there's a positive test, and that's for an employee or a family member for whom the employee is providing care tests positive for COVID-19. And family member is defined under the California Labor Code, and it's in a separate section than the paid sick leave, but it does define specifically who counts as a family member. And then for this bucket where you have an employee or a family member who tests positive, the employer is allowed to require that employee submit to a second test on or after the 5th day after the first positive test, and to provide documentation. And the employer can require that documentation, and if it's not provided, can not provide the leave. So it is possible to require documentation of positive test results and subsequent test results. And then, of course, in line with a lot of the other California guidance and requirements, that testing does have to be made available to employees at no cost to them. Some additional details, and we do expect there to be lots of questions about this paid sick leave requirement. There is quite a bit of detail in the law about the calculation of eligible hours. It's easy if you have an employee who works full-time, or in the 2 weeks prior to their leave was scheduled to work an average of 40 hours a week, because then they're eligible up to that maximum of 40 hours for each bucket of time. The calculation, however, differs a little bit if you have employees who work less than that, or interestingly enough, for firefighters. In terms of, additional things to keep in mind when implementing this new sick leave program, there is something to keep in mind in terms of the wage statements. You may be familiar with the requirement to include the allotment of regular California paid sick leave on a wage statement. So this COVID-19 supplemental sick leave has to be identified separately on a wage statement, or if that information is communicated to employees in a different way, then it would need to be, again, separately designated. Just as with the prior version of supplemental paid sick leave, there are payment caps, both a daily cap and a total cap. And then if an employee, if you have a question about the retroactivity, how that works, so the employee is supposed to make an oral or written request, and then if they've made that oral or written request, the retroactive payment would be due on or before the payday for the next full pay period after the request. And again, we are expecting there to be lots of questions about this law, and we know that the Department of Industrial Relations is updating their website, and we expect them to issue not only model notices, it was required of them under the legislation, but also expect to see frequently asked questions issued from them as well. There is, we did want to mention an update to the California Family Rights Act. Although it is a relatively minor update this year, it is in the context of a much more significant update that happened last year. In case you missed that, I just want to go over it so that the new update makes sense. So the legislation that went into effect in 2021 expanded CFRA eligibility quite a bit, because it's no longer 50 or more employees, and there's no longer any geographic limitation. It applies to employers with 5 or more employees, period. They also removed some significant restrictions that existed. One was for employers who employed both parents. There was a limitation in the ability to restrict it to one parent. And then if you had employees that qualified within the definition of a key employee, you used to be able to, there was an exemption from the right to reinstatement for that employee, and that key employee exemption no longer exists. There was also some expansion in terms of the family members that were covered, so that essentially CFRA rights would provide 12 weeks of unpaid protected leave during any 12-month period of time for qualifying reasons. including the birth or adoption of a child, for an employee's own serious health condition, or to care for certain family members. And that's where the update matters that I'm going to talk about in just a moment. As you may know, CIFRA also provides eligibility for certain qualifying leaves related to covered active duty. So then the change that went into effect January 2022 kind of clarifies a little bit of an error, perhaps, that was made in the 2021 version, where they added a definition of parent-in-law as a covered family member, but then they omitted it from the actual list of covered family members. So they've cleaned that up. So parent-in-law is included. And then they've added kind of an interesting focus. There was a small employer mediation program that essentially was encouraging employees to engage in mediation before filing suit. And for a brief period of time until this provision sunsets, just this mediation provision sunsets in January of 2024, if an employer is served with a lawsuit and wasn't given the required notice, there is an opportunity to put a pause on the litigation to conduct the mediation and then continue with litigation if the mediation is unsuccessful. So that's the CIFRA update. There was also an expansion of existing law relating to settlement agreements and non-disparagement agreements. A few years back, there was an update to the Fair Employment and Housing Act, which made it unlawful employment practice for an employer to, in exchange for a raise or a bonus, or as a condition of employment, to essentially restrict an employee's right to disclose information about unlawful acts in the workplace. And if you recall, this was a response as part of the Me Too movement to make sure that agreements weren't restricting employees' ability to discuss unlawful acts, particularly sexual harassment and sexual discrimination. Senate Bill 331 expanded that so that it's not limited to sexual harassment, discrimination, and retaliation, but rather includes all acts of workplace harassment, discrimination, or retaliation based on any protected category. And then separately, Senate Bill 331 includes a requirement where if you have an agreement that's being offered to an employee as part of their separation, a severance agreement, or a settlement agreement that comes out of an informal dispute after, say, termination, but the employee has not actually filed a claim or filed a lawsuit, then you have to notify the employee of their right to consult an attorney. And we recommend adding language to any of your separation agreements or severance agreements to address that. This doesn't apply to a negotiated settlement agreement in the context of a filed claim in court or before an administrative agency or under other certain circumstances, but it is something to keep in mind in case you do enter into an agreement with an employer or former employee where there is no such claim or formal claim process happening. Moving right along to our quota legislation. So this is really, really fascinating stuff for people who like Andrew and I, who are very interested in this. So this might sound like a workplace safety issue, but there is a wage and hour component to this warehouse distribution quota law. This essentially came out of, like Andrew alluded to, essentially came out of a perceived issue with warehouse practices, particularly in Amazon warehouse centers. So this law is limited to certain warehouse employees defined under certain industry codes. And it depends on how many warehouse employees or how many warehouse employees you have in a given warehouse distribution center or statewide. And essentially, there's a couple requirements that came with this quota regulation, or excuse me, quota legislation. One is that an employer must disclose a written description of all quotas that apply to a warehouse employee. And they're supposed to provide this either upon hire or within 30 days of the law going into effect, which at this point, we're already past that deadline. The quota themselves cannot prevent an employee from taking their meal or rest breaks, from using bathroom facilities, or from complying with other occupational health and safety laws. And if the quota violates that restriction, then an employer is not allowed to subject the employee to adverse action based on that quota. So if they say you violated the quota, but the employee comes back and says, but the quote, under the quota, I don't have enough time to use the bathroom, or I don't have enough time to take my rest break, then that is the concern that's being addressed by this new rule. This also comes with a rebuttable presumption of retaliation, where an employee is subject to adverse action within 90 days of engaging in protected activity under the quota law. And that protected activity would include either complaining that the work quota is unlawful, or even just merely requesting information about the quota or information about their own personal work speed data, whether or not they're meeting the quota, essentially. And if an employee requests a written description of their quota that applies to them or their own work speed data, they're entitled to, there's some restriction in what they're able to ask for. They get it over the past 90 days, and they're restricted in the number of times they can ask for it in a given calendar year. But the important part to remember is that employers have 21 days to respond to that request. And the exposure point here is that employees can certainly request injunctive relief, but attorneys' fees and PAGA penalties are on the line here as well. And PAGA penalties, you're already talking about employer locations that have a fair amount of employees, given the definition of employees and employer under the law. And as we've discussed before, PAGA penalties can add up rather quickly. So if this applies to you, this is definitely something to pay attention to. And then one that got a little bit less coverage, but is still in existence, is one that applies to chain community pharmacies. And that's defined as essentially chain stores of 75 chain businesses, of 75 or more stores in California under the same ownership. And though if you qualify under that law, then pharmacists or pharmacy technicians, those for whom a pharmacy technician license is required, cannot be subject to a quota. And this one appears to stem from a concern regarding COVID-19 testing and vaccination, that given the high demand and the pressure to get people vaccinated and get people tested, that there might be mistakes made if there were quotas that were in existence. So that's an update on the little quota laws. And then we always, every year, have kind of a handful of random wage and hour developments. And I'll just run through them rather quickly, just so that you're aware of them in case they do apply. Assembly Bill 1003 is, one that sounds it's a lot of legalese, and it talks about the definition of grand theft. And essentially, the thing to note here is that it kind of ups the ante in terms of wage and hour violations, because it defines grand theft to include the intentional theft of wages, and grand theft is a felony. So it increases the risk and the exposure for intentional theft of wages. And it's really just a reminder to employers about the importance of wage and hour compliance, and perhaps considering auditing wage and hour practices if there's a concern there, to make sure that those compliance issues are being addressed. Senate Bill 62 has to do with garment manufacturing, and it essentially prohibits employees in the garment manufacturing from being paid piece rate. So that is off the table as a way to pay employees in garment manufacturing. Senate Bill 93 is not new. It was a piece of emergency legislation that went into effect back in April of 2021. And it essentially requires some rehiring and retention requirements for employees who lost their jobs due to the COVID-19 pandemic. And it is limited to certain hospitality industries and to those who provide building service to office, retail, or other commercial buildings. But the reason why we wanted to mention it is because if you'll notice, it doesn't sunset until December 31st of 2024. And it brings with it some requirements to give notice to employees who lost their jobs. So if you had a layoff and employees, went about their business, you may still continue to have obligations under this law for the next 2 years. And some of those obligations include, notification of job opportunities or job postings and things of that sort. So something that, even though it went into effect a while ago, it's still something to keep on your radar if it applies to you for a little while longer. Senate Bill 572 just allows the labor commissioner to create a lien on real property to secure amounts due to the commissioner. Previously, they've been able to issue judgment liens, but not liens on real property. And then Senate Bill 646 creates an exemption from PAGA penalties for janitorial employees where there's a collective bargaining agreement that meets specific requirements. And then one last little update is in the context of FEHA claims, so Fair Employment and Housing claims. So this is where we see our discrimination, retaliation, harassment claims, and other claims come out of this. So they've added an additional jurisdictional basis so that employers can be sued where they have their residence or principal office. And then the second one is kind of a big one, because if an employee brings a class action or a representative action under PAGA, for example, then they are permitted to sue in any county in the state of California. This modification to DFEH procedures also extends statute of limitations for certain claims. And most importantly, it expands the employer retention requirement from 2 years to 4 years. So it's definitely one to track in updating any record retention policies that exist to make sure you're in compliance with that one. And then minimum wage, we've been tracking kind of this increase to $15 an hour over the last many number of years. January 1st, the California minimum wage is now $14 for employers with 25 or fewer employees, and $15 an hour for employees with 26 or more employees. We will see that category of smaller employers finally reach the 15 per hour next year, January 1st, 2023. And as if that's not enough, of course, you have to remember to check your local ordinances for employees who may be working in any of the jurisdictions that may have higher minimum wages or other such requirements. And with that, sorry to go through those updates so quickly, but those are the rest of our kind of labor and employment updates. And I will turn it back over to Andrew. I know we probably got lots of questions through that second half.
Right, yeah, there certainly are a number of questions. So we'll do our best to answer as many as possible now. I wanted to just highlight that for additional resources, you can subscribe to our blogs. We have an OSHA blog, a Cal-OSHA blog, and also an employer defense blog. I believe our Cal-OSHA blog is not listed. I'm horrified by that. But you can subscribe and receive timely updates on developments, and anything that's we view as a significant development in the employment in the CalOSHA realm, we're putting on our blog. So that's a good way to kind of get an advance notice of these developments. But wanted to address some of the questions here. One question here was, if the COVID-19 test is not observed, will a positive rapid trigger test, will the test trigger the outbreak section of the ETS? So that's an interesting question. There is a requirement, outbreak section. So if you look at, if you have an employee who is a COVID-19 case, you must exclude that person from the workplace, regardless of whether there's an outbreak. A COVID-19 case is someone that tests positive as defined, has a positive COVID-19 test as defined by the section, but it also is an individual that has a positive diagnosis from a licensed healthcare provider. So there's a couple triggering events. I would view it as inconsistent with the intent of the ETS to tell an employee, well, you haven't, we don't have an observed test, therefore we're not going to treat it as positive and we're not going to follow the requirements under the ETS. But also it's incumbent upon the employer to ensure that there is a compliant COVID-19 test. So if it requires observation, it's on the employer to ensure that that's done. That's how I view it, at least. And then for outbreak, that's also within the control of the employer to ensure that the testing protocols are followed. So I would say that if an employee tells you that they are positive, to treat it as a positive case despite proof, and then to follow up to ensure that testing has occurred. And then there were some questions about face coverings applying to Los Angeles City. Megan, are you aware of the current requirement for face coverings in LA County?
I wouldn't want to speak off the top.
Oh, okay, so we would, the person that raised that question, if you want to reach out to us individually, we can get you an answer. Our team is advising on this, but we have different folks that are doing that, and these changes are constantly evolving. And so this just reinforces that you need to look at the county where you are located, and there are counties like Los Angeles, San Francisco, Santa Clara that have requirements that go beyond the ETS. And so scroll down here. All right, and there was a question about, let's see. Please confirm whether the California paid sick leave, whether it's available for employees eligible for exclusion pay. So Megan reviewed the California paid sick leave eligibility criteria, and as you can see, it overlaps with the exclusion pay, the exclusion requirements under the ETS, and goes broader than that. So you would technically look at the framework for eligibility under the California paid sick leave in determining whether you need to pay out this this pay. But you would also, for all intents and purposes, it's applying to excluded employees per the ETS. And then we'll see in the coming months whether the exclusion pay is repealed from the ETS, but it is somewhat duplicative. And there was a question, does this need to be reflected on their paychecks? I think that's referring to the supplemental paid sick leave. Megan, do you want to answer that?
Yes, it should be. There is an alternate way to provide the sick leave bank, the earned and available sick leave. You can provide it in a separate writing at the time that you provide the wage statement, but typically it's provided on the wage statement. So yes, if your regular paid sick leave is appearing on the wage statement, then there should be a separate line for the COVID-19 supplemental paid sick leave.
All right, so and then there was a question to receive 80 hours of California paid sick leave. Can we require a second positive test? Megan, do you want to answer that?
So it does allow you to, so it would, if you have a COVID positive person and you're pulling from the 40 hours for positive cases and you reach a point in time, you know, say 5 days after the initial test, and they're saying, I still have symptoms, I still need to be out, then at that point, yes, you can require a second positive test to continue paying them out of their remaining available supplemental paid sick leave.
And that's distinguishable from the ETS, where there is no recognition of an ability of an employer to request a second test, or to require, you can request it, but to require a second test. And there was another question, Megan, about how does the supplemental paid sick leave law apply to healthcare? Is the scope of the application broad?
It is. It is. I don't, so employers are, I know there were some different rules that applied for firefighters, but I don't recall there being any specific differences for healthcare. There could be something buried in the legislation, but an employer, I can check the different, you love when these labor code sections refer to other labor code sections and send you on a wild goose chase. There may be some carve outs based on how employer is defined under a different code section under employment law, but I'd have to check that to be sure.
Oh, okay, and we can circle back on that as well. And it says, does the law speak on anything regarding testing requirements done at a certified testing site or allowed at home tests? It's the definition of COVID-19 test under the ETS is what has imposed these additional requirements for observation by the employer, you know, essentially where it's not a proctored test by a third party or a laboratory test. And so there is a requirement for employer observation. I believe it would be permissible for an employer to observe the testing by video. That could be, you know, a FaceTime, you know, on the phone where you could be observing the testing as it's done. The other way to get around the observation requirement is if you have a digital test where it's date stamped. In that situation, there is a recognition that there does not need to be employer observation. But my understanding is those tests are not easy to come by and are costly. I'm referring to the digital tests. All right. This is an interesting question. I'll pose this to you, Megan. Does the warehouse quota bill extend to delivery drivers from warehouses?
Great question. That is one for us to ponder, because the way that they define the employees are those that work at the warehouses. So there could potentially be some ambiguity there.
Right, and I mean, I would, you know, we could look at the legislative history, but the intent seems to be a focus on warehouse workers. And I think in the legislators' mind, they were focused on Amazon warehouse workers. It's not the drivers who are working independently. But that can certainly be a discussion point. Okay, and there was another question. Okay. And for, I guess, Megan, for the paid sick leave laws, is there any numeric requirement for the number of employees for the law to apply?
Yes, employer is defined to include those that employ more than 25 employees.
Got it. And is that, there was a question about whether employee includes contractors or employees out of state. And I, I'll add that, typically under the California employment laws, when they talk about an employee as a threshold matter for a law to apply, they typically refer to any employees by the employer regardless of where they're located. Do you recall, Megan, offhand, whether that definition of employee is similarly broad?
Yeah, it's not restricted, so we would consider it to apply across the board out of state as well.
Okay, and then there was a question: must an employee stay isolated, quarantined for the full 10 days if he or she tests negative but still complains? Oh, this is a really good question. So if an employee tests negative for COVID, so if the employee tests negative, they wouldn't need to isolate, they wouldn't be a positive case, but they may need to quarantine because they had a close contact. But if they still have COVID-19 symptoms, they are required to quarantine. And so, that's a bit of a challenge because the definition of COVID-19 symptoms includes so many different symptoms that are unrelated to COVID, that could be related to allergies or other conditions. And I know throughout the pandemic, I've had symptoms related to allergies that would, under the definition of COVID-19 symptoms, qualify. And that is a bit problematic. And there's ways to navigate this. You may have employees that are, being candid and truthful and might not be focusing on symptoms that they know are not COVID related. But where there's a gray area, there may be an ability to have some follow-up with the employee on this. Okay, and then there was a question: is there anything for employers with less than 25 employees? And that, I assume that's referring to the California Supplemental Paid Sick Leave. So, and Megan, correct me if you disagree, but if you have fewer than 25 employees, you would not be subject to the Supplemental Paid Sick Leave, but you would still be subject to the exclusion pay provision in the ETS.
That's right. And depending on the reason why the person needs the leave, there may be California or local, just regular paid sick leave that might be in play. But assuming that that pay has been spent, then yes, then you're just looking at the exclusion pay requirement under the ETS.
Okay. So I think with that, we're going to end the webinar. We appreciate your participation, all the really good questions, and apologies if we weren't able to answer all of them. But if you have any further questions, we'd love to be a resource. We kind of live and breathe these employment and workplace safety issues. And again, thanks for participating.